If you're arrested for a DUI in Florida, you only have 10 days to save your driver's license. It's called the 10-day rule. Shocker, I know. But let's really break this down, what this is and what this means, because it's so essential. And it's only 10 days that you have to do it, and you have to do it right. That's the key. In the state of Florida, whether you have a Florida driver's license or not, because they're looking at not just your Florida driver's license, but your right to drive in the state of Florida, okay? So it matters for anybody who gets a DUI in the state of Florida. You only have 10 days to challenge the suspension at the DMV. So the first thing I want you to think of, when you get arrested for DUI, two things happen at the same time. You have the right hand, criminal case, prosecutor, judge, maybe a trial and a jury, criminal penalties, jail, fines, probation, all the things that you know that are going on from being arrested for committing a crime. But you also have the left hand, which is the DMV administrative procedure of, listen, I gave a breath test. It was over the legal limit. My license is going to be suspended for 6 months. What do I do? Or I refused a breath test. My license is going to be suspended for 12 months if it's my first time refusing, or 18 months if it's my second time refusing. What do I do? How do I get my license back? Can I get a hardship license? What is this whole process and procedure? And that's what this video is going to be about. This left-hand process, which is the 10-day rule. Now, as we're going through this analysis, there's a major thing that everybody watching this video needs to consider. There's a few major differences between criminal lawyers who will handle DUI cases and real DUI experts that this is what they do, this is what they know. So I want to take a minute for you to just think about that and really listen to what I'm saying, because on a case that's so nuanced as DUI law, you have to have DUI experts handle this. You can't just have a criminal lawyer who, kind of, sort of, maybe will do this. So there's a few differences, but for the purpose of this video, let me tell you the major one for the 10-day rule analysis. If you speak to a criminal defense lawyer and the criminal defense lawyer doesn't discuss the 10-day rule with you, or says to you just, well, go to the DMV, you can handle it on your own, I don't do that. Run away. Run away immediately. That is a criminal lawyer. That is not a DUI expert, okay? Now, some people might say, well, yeah, Adam, but that criminal lawyer is going to charge me just, a few $1,000s and it's going to be much cheaper. Well, I can tell you it's going to cost you 10 times in the long run, because they don't know what they're doing and they're potentially giving you bad advice. So what I believe and what we do with all of our clients is we need to have a discussion about the 10-day rule and about what these options are so you can make the best choice for yourself. By you going to the DMV and just doing it yourself, odds are you're going to screw it up. And unlike you maybe screwing up, a DIY kit on your toilet at home, okay, this is going to have much longer and much more significant impact for you, for your family, for your future. So you don't want to DIY it. You don't want to hire that criminal lawyer that's going to leave you out on an island and just tell you to handle it by yourself. So let's break it down. What are your options? If it's a first-time DUI, you actually have two choices, okay? And this is really important. If it's your first DUI, you have the option to either fight the case at the DMV, okay? Go through what's called a formal review hearing and fight the whole process. Or you have the special option for first-time people, which is waive your right and get the hardship immediately. Now, some people might say, whoa, hardship immediately, that sounds great and amazing. Well, not so fast, my friend, because what you're not told is the truth behind it, okay? So let me tell you the truth behind this, okay? When you go to the DMV, and when you waive your right to go through this process and to have this mini trial at the DMV, what you're doing is you're pleading guilty at the DMV. And it's going to be on your driving record for the next 75 years. The DMV won't tell you this, and these criminal lawyers won't tell you this. It's not always a bad thing to have happen, but I'm a big believer in personal choice, and you need to know what's going on. So here are the pros. Okay, the pros to this is, well, it's a guaranteed way to get your hardship license, meaning you're going to have your hardship license for 6 months or 12 months. Okay, it's basically guaranteed so long as you're eligible. The downside is, well, now you've admitted guilt at the DMV. It's on your driving record for 75 years, and we're not going to have a mini trial to subpoena officers and witnesses and grill them on the case. And the great part of that is by getting an early chance to read the reports, grill the officers and witnesses under oath at a hearing, we can actually use this from the DMV process. We can use it to benefit your criminal case. Okay, so it's a very big deal that we can have, that we can really use for your benefit. Well, what's the second option? So the second option is we fight it. And when we fight it, okay, and look, either way, we do all of this for you. So my firm is fully custom. We do this for you. We don't put you out on an island. We don't let our clients do a DIY process. So either situation, we'll do it for you. But we go ahead and we request a formal review hearing. The DMV is going to set this hearing out usually within 30 days, and they're going to give us a 60-day hardship permit to give to you. So for the next 60 days, hardship license, work, school, religion, kids, attorney, groceries, medical, anything you need to maintain your life, your livelihood. And then we're going to have this mini trial. We're going to subpoena witnesses. We're going to spend the money on subpoenas and on court reporters to get them to show up to this hearing. You're not going to be there. We're there. And we grill them. We question them. And I can't tell you how many times, because there's been so many, where I'm questioning a witness and I think the case might be a tough case. And then they say something and I go, oh my God, that wasn't in the reports. Just like that, we're going to win this criminal case now because of what this person said here today. And if I didn't do this hearing, if I didn't have a conversation with our client and we didn't decide that this hearing was essential, I might not have ever found this out. I might not have ever beaten this case, this criminal case. Thank goodness we went ahead and we did the work and we did it early. Now, if we win this hearing at the DMV, and they're hard to win, but we do win. Okay, so don't let a lawyer tell you, oh, they're impossible. They're not impossible. We win them. They're hard, but we win. And if we win, you get your full driver's license back like that. It does not automatically mean you're going to win the criminal case. It gives you your full license back with no restrictions. Now, what happens if we lose? There's a hard suspension period, which means there's no driving whatsoever for a period of time. If it's a breath test, it's going to be 30 days. If it's a refusal, it's going to be 90 days. And if it's your second time refusing, then you're done. It's an 18-month hard suspension no matter what. But if it's your second DUI, you don't have the option to waive the formal review and take the guarantee. If it's your second DUI, the only option that you have is to go ahead and fight it at the DMV. Okay, and I've also seen cases where lawyers have given misadvice, not known that it was a second DUI arrest, and just told people to go waive it. They go try to waive it. The DMV says you're ineligible. The DMV won't tell you what to do. And then before you know it, the client calls us on maybe day 20 and we go, you got terrible advice. Had you called us, we would have handled this all the right way. So again, it's very important that you call DUI experts within that first 10 days. But going back, when you have this hard suspension, whether it's 30 or 90 days, when that time is up, you can go and reapply for your hardship license so long as you go to DUI school and you go through that process. And these are things that we tell all our clients what to do. We have a roadmap for them because already as I'm telling you this, your mind's probably spinning going, oh my God, this is so confusing. Well, look, it might be confusing for somebody who's the first time they've ever done this. It's not confusing for us. And again, that's the major point of this. You only have 10 days. You need experts that are going to tell you what to do, break it down simply and easily for you, guide you through this process. You don't need a lawyer to put you on an island and say, well, I don't do that. I just do the criminal case. Go handle it. Okay, that's one of the worst things that you can do. And remember, the 10-day rule starts from the day that you're arrested. So by the time you get out of jail, by the time you get your car back and all these things, that clock is ticking. You easily could be at day 1, 2, or 3, and then all of a sudden you might only have 7 days left. So you gotta hurry, you gotta move really fast on these cases. So hopefully this explains the 10-day rule. Hopefully you understand this. If you have any questions, give us a call right away. We'd love to help you out at the Rossen Law Firm, 754-206-6200.